Good day, everyone. I am Danica Gabriel Ruado. I am part of Group 9, Constitutional Law 2, and we will be reporting our assigned cases for today. The first case is People versus Tampal. The facts of the case are Luis Tampal, Domingo Padumon, Arsenio Padumon, Samuel Padumon, Pablito Suco, Darlo Suco, and Galvino Cadling were charged of robbery with homicide and multiple serious physical injuries in the Regional Trial Court of Zamboanga with Honorable Wilfredo Cotorena as presiding judge. However, only private respondents Luis Tampal, Domingo Padumon, Arsenio Padumon, and Samuel Padumon were arrested while the others remain at large. The case was set for hearing on July 26, 1991, but Assistant Provincial Prosecutor Wilfredo Guantero moved for postponement due to his failure to contact the material witness. The case was reset without any objection from the defense counsel. The case was called on September 20, 1991, but the prosecutor was not present. The respondent judge considered the absence of the prosecutor as unjustified and dismissed the criminal case for failure to prosecute. The prosecution filed a motion for reconsideration claiming that his absence was due because that date was a Muslim holiday and the office of the provincial prosecutor was closed on that day. And that motion was denied by the respondent judge. The issue is whether or not the postponement is a violation of the right of the accused to a speedy disposition of their cases, and whether or not the dismissal serves as a bar to the reinstatement of the case. The ruling of the Supreme Court is that, in determining the right of an accused to speedy disposition of their case, courts should do more than a mathematical computation of the number of postponements of the scheduled hearings of the case. What are violative of the right of the accused to speedy trial or unjustified postponements, which prolong trial for an unreasonable length of time. In the facts above, there was no showing that there was an unjust delay caused by the prosecution. Hence, the respondent judge should have given the prosecution a fair opportunity to prosecute its case. The private respondents cannot invoke the right against double jeopardy. In several cases, it was held that dismissal on the grounds of failure to prosecute is equivalent to an acquittal that would bar another prosecution for the same offense. But in this case, this does not apply, considering that the rights of the accused to a speedy trial was not violated by the state. Therefore, the order of dismissal is annulled and the case is remanded to the court of origin for further proceedings. The next case is Melo versus People. The facts of the case are, the petitioner was charged in the court of first instance with frustrated homicide for having allegedly inflicted upon victim with a kitchen knife and with intent to kill several serious wounds on different parts of the body, requiring medical attendance for a period of more than 30 days. And incapacitating him from performing his habitual labor for the same period of time. On December 29, 1949, at 8 o'clock in the morning, the accused pleaded not guilty to the offense charged, and at 10:15 in the evening of the same day, Benjamin Obelon died from his wounds. The evidence of death was available to the prosecution only on January 3, 1950. And on the following day, January 4, 1950, an amended information was filed charging the accused with consummated homicide. The accused filed a motion to quash the amended information, alleging double jeopardy, motion that was denied by the respondent court. Hence, the instant petition for the prohibition to enjoin the respondent court from further entertaining the amended information. The issue is whether the amendment of the information charged against the accused constitute double jeopardy. The ruling of the Supreme Court is no. It must be noticed that the protection of the Constitution inhibition is against a second jeopardy for the same offense. The only exception being, as stated in the same Constitution, that if an act is punished by a law and an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. The phrase same offense under the general rule has always been construed to mean not only the second offense charged is exactly the same as the one alleged in the first information, but also that the two offenses are identical. There is identity between the two offenses when the evidence to support the conviction for one offense would sufficient to warrant a conviction of the other. This so-called same evidence test, which was found to be vague and deficient, was restated by the rules of court in a clearer and more accurate form. Under said rules, there is identity between two offenses not only when the second offense is exactly the same as the first, but when the second offense is an attempt to commit the first or a frustration thereof, or when it necessarily includes or is necessarily included in the offense charged in the first information. In this connection, an offense may be said to necessarily include another when one of the same essential ingredients of the former as alleged in the information constitute the latter, and vice versa. An offense may be said to be necessarily included in another when all the ingredients of the former constitute a part of the elements constituting the latter. In other words, one who has been charged with an offense cannot be charged again with the same identical offense, though the latter may be lesser or greater than the former. As the government cannot be with the highest and then go down step to step, bringing the man into jeopardy for every dereliction included therein, neither can it begin with the lowest and ascend to the highest with precisely the same result. Thank you so much. This is my part of our report, and the next topics and cases will be presented by my group mates.
Let's talk about the case of People vs. Balisacan. This is a 1966 case involving double jeopardy, which is actually just a pretty simple case. So let's start with the facts of this case. So this involves Aurelio Balisacan, who actually stabbed Leonicio Bulaot, which resulted in his death. So for that death, he was charged with homicide in the trial court of Ilocos Norte. And during his arraignment for this homicide case, Aurelio pleaded guilty. So he pleaded guilty so that he could present evidence to prove any mitigating circumstance. But during his testimony, he actually said that the only reason he stabbed Dionisio was in self-defense, claiming that he was going to be strangled by Leonicio. So he defended himself, resulting in the stabbing and subsequently the death. And as for this case, it was actually acquitted, or Aurelio was actually acquitted. So upon the acquittal, an appeal was made. An appeal was made to the Court of Appeals, which then moved on to the Supreme Court. The reason it was moved on to the Supreme Court was because the appeal involved a question purely of law. And what is that question? That is the main issue of this case. And it is whether or not an appeal challenging the acquittal of Aurelio constitute double jeopardy. Because we have a standing rule here that an appeal cannot be made if it would constitute a double jeopardy. So in this case, what actually happened is that no, it was not. There is no double jeopardy in this case. Why is that? Even though Balisacan claimed or pleaded guilty, his subsequent use or claim of self-defense actually vacated the plea, meaning he's no longer under the plea of being guilty. So he should have been required to plead anew or give a new plea, or at least be directed to plead at not guilty. But that did not happen. So what happened was there was no standing plea. So by the time he was acquitted, there was he has no actual plea. He was not guilty. He was just acquitted. So there cannot be any double jeopardy in this case because again there was no plea of guilt. Second here is while the trial court also decided upon the merits, they were not, or the prosecution was not given any opportunity to present its evidence. So it was not given any chance to rebut the testimony of Aurelio. They just followed through with the fact that he said that it was self-defense. So in that case, it means that they acted without the due process of law. So this is a fundamental prerequisite, of course, and not acting on that, meaning that the action was null and void. So therefore, the acquittal being null and void, it cannot constitute a proper claim for a basis of double jeopardy. Because again, it was not done under due process. So let's talk about the main doctrine of this case. As I stated earlier, there's an actual rule, and that rule would be Section 2, Rule 122 of the Rules of Court. And this provides that the people of the Philippines cannot appeal if the defendant would be placed thereby in double jeopardy. So in this case, it was valid, the appeal was valid, but the case was actually remanded back to the trial court because again, it did not follow through with the due process, so it needed more proceedings. Thank you. Let's talk about the case of People versus the City Court of Silay, also a 1976 case involving double jeopardy. So what are the facts of this case? We have three main individuals here: Pacifico Asensio, Romeo Milan, and Wilfredo Jochico. So these three are scalers that works for the Hawaiian Philippine Company, and what they do is they weigh cane cars or sugar cane cars, and they place the weight on a tarjeta, which is a weight report card. But it was actually found out that they were actually falsifying the weight of these sugar cane cars. What happened is they were actually making it out to seem that it's heavier than it actually is. So for that, they were actually charged with falsification and the use of falsified documents, referring to the tarjetas or the weighted report card. But the respondent here actually moved to dismiss the charge against them. And the reason being is that the evidence presented against them were sufficient or not sufficient to establish their guilt beyond reasonable doubt. So what actually happened was the court on this motion actually issued an order dismissing the case and claiming that the accused do not constitute the crime of falsification as it is strictly enumerated in the revised penal code. So for that, it was dismissed. The people here asserts that a plea of double jeopardy is not tenable, even if the case at bar was dismissed, because according to them, it was done with the consent of the accused. So therefore, he waived his right to defense of double jeopardy. But what happened here is the accused actually, or the accused, reiterated the fact that the dismissal was due to the lack of merits of the prosecution. So it would in effect be the same as an acquittal, and it will bar the prosecution from actually filing that appeal, since filing that would mean it would be double jeopardy. So what is the main question here in this case? So as stated earlier, this is a double jeopardy case. So whether or not that petition or that appeal for that three person would constitute double jeopardy. On the previous case, we also learned that an appeal may not be made if it would result in double jeopardy. The court ruled that yes, it would actually result in double jeopardy. Since the earlier case was already dismissed due to lack of merits, and while it is true that the case for falsification was dismissed upon the motion of the accused, it was only also done after the prosecution has rested its case. So in that scenario, it is tantamount to an actual acquittal. And since it is an actual acquittal, the prosecution is actually barred from filing another case. Since again, it will be a double jeopardy. While the complaint against the three was actually valid, the charge against them was actually not sufficient enough to prove them guilty beyond any reasonable doubt. So it resulted in the dismissal of the case. And again, it transmits to or translates to an acquittal. So there are two instances here that we can conclude that there's actually jeopardy. So on the first ground is that due to the insufficiency of evidence. Again, that was the first reason. We also stated that it was lacking merit. So for the second one, proceedings have been prolonged and prolonged to a state that it would be considered as a violation of the right of the accused to a speedy trial. As per the doctrine of this case, a valid defense of double jeopardy is first that the complaint should be valid, and second that this valid complaint should be filed before the competent court and to which the accused has pleaded, and that the defendant was previously acquitted, convicted, or dismissed or otherwise terminated without express consent of the accused. And that would be all for the case. Thank you.
Hello, I'm Aaron, and I will be discussing the next case, which is the case of Ismenia versus Pogoy. In the case of Ismenia versus Pogoy, the petitioners, along with their co-accused, were charged of grave coercion. They allegedly forced Father Tibudan, the complainant in this case, to withdraw a sum of money from the bank to pay the accused because he had lost in a game of cards. This case was scheduled and rescheduled multiple times, once by the fiscal, and three times because of the complainant. Uh, the fiscal claimed that one of the reason that he had requested for a reschedule was because he lost the record of the case. And in the final date ordered by uh, the judge, the complainant was not able to attend, uh, and as well as in one of the other times, arraignment was held but with no trial, and the accused pleaded not guilty. So on the final date that the complainant was not able to appear, he claimed that the fiscal claimed that he was informed by the complainant he would not be able to appear because he was sick, but was not able to provide a medical certificate. The petitioners counsel invoked the right of the accused to have a speedy trial. The respondent judge provisionally dismissed the case, and on a later date, the fiscal filed a motion for the revival of the case, and that the ruling that a provisional dismissal with conformity of the accused lacks the impress of finality, and this was unopposed by the accused, which the judge granted. Along with this filing, the fiscal also provided the medical certificate to prove that uh, Father Tibudan was actually sick. That's why he was not able to attend the final date as ordered by the judge. Now, the counsel of the accused filed a motion to dismiss the case on the ground of double jeopardy, which was denied by the respondent judge. So the issue is whether or not the rule on double jeopardy applies in the provisional dismissal of the instant case. So the court ruled that yes. The court also enumerated the elements that must concur for the existence of legal jeopardy. Namely, that is a valid complaint or information. B, before a before a court of competent jurisdiction, and C, the accused has been arraigned and has pleaded to the complaint or information. This was all present in the instant case. Previous acquittal, previous conviction, or the dismissal or termination of the case without his consent precludes his subsequent indictment for the same offense as defined in Section 9 of Rule 117 of the Rules of Court. The court ruled that in the instant case, the petitioners were placed in jeopardy by the provisional dismissal of the criminal case because it was not clear when the respondent judge had provisionally dismissed the case that the accused had consented to such. The court also said that it would not have been so if respondent judge took precaution of making sure that the dismissal was with the consent of the accused. The court dismissed the order of the respondent judge to revive the case as it violates the rights of the accused against double jeopardy found in Section 22, Article 4 of the Constitution. The next case is People versus Pineda. Private respondent in the case is Consolacion Naval, who was charged with estafa and falsification. Both charges were in different courts, and she sought the quashal of the falsification charges in fear of being convicted for the same felony. Naval pleaded not guilty to the charge of falsification. Judge Pineda believed that the alleged falsification was a necessary means of committing estafa and granted the motion to quash. Now, the issue is whether or not Consolacion Naval was in danger of being convicted twice for the same felony. The court ruled that no, the mere filing of two informations charging the same offense is not an appropriate basis for the invocation of the double jeopardy, since the first jeopardy has not yet set in by previous conviction, acquittal, or termination of the case without the consent of the accused. The court found that the lower court was mistaken to have shared the notion that private respondent was in danger of being convicted twice for the same criminal act as suggested in the motion to quash, because this plea is understood to presuppose that the other case against private respondent has been dismissed or otherwise terminated without her consent by a court of competent jurisdiction upon a valid complaint or information and after defendant had pleaded to the charge. And thus, the petition was granted.
To continue the report of Group 9, I am going to discuss the last two cases. Let's start with the case of People versus Adele. The case was a petition for certiorari to set aside the dismissal of the criminal case number 5241 of the Court of First Instance of Iloilo against the private respondent Margarito Fama Jr., dated September 22, 1975 and October 14, 1975, by the respondent Honorable Midpantao El Adil, the presiding judge of the Court of First Instance Iloilo Branch 2. Fama claimed that he was under double jeopardy in relation to the case previously dismissed by the Municipal Court of Iloilo in criminal case number 3335. To give us a clearer view, criminal case number 3335, which was the first case, stated that there were slight physical injuries caused to Miguel Viajar by Fama Jr., who willfully, unlawfully, and feloniously assaulted and attacked him through physical violence with a piece of stone. In here, it was claimed that 5 to 9 days bearing complication was present according to the medical certificate issued by the physician. It was arraigned and he pleaded not guilty. On the other hand, the criminal case number 5241, which was the second case, stated that there were serious physical injuries from the same incident, and the fiscal filed in the Court of First Instance of Iloilo an information, but only against the respondent Fama Jr. So Fama Jr. asked to defer the proceedings since he was already charged for the same case and he pleaded not guilty. So in here, the fiscal opposed, and the court asked both parties to file memorandum on the issue of double jeopardy. The fiscal sought dismissal of criminal case number 3335, but the municipal court did not act. Instead, the case was set for hearing, and in view of the postponements asked by the fiscal in order to await the resolution of the issue of double jeopardy in case number 5241. The issue that was resolved here was whether or not the respondent, Fama Jr., is in double jeopardy. And the court said no, the plea of double jeopardy of the private respondent, Fama Jr., cannot hold. The court stated that accordingly, the orders of September 22, 1976 and October 14, 1975 herein complained of are hereby set aside and respondent court is ordered to proceed with the trial and judgment thereof according to the law, caused against private respondent Fama Jr. What was controlling in this case of People versus Adil was the ruling in the case of Mello versus People. It was held that this rule of identity does not apply, however, when the second offense was not in existence at the time of the first prosecution, for the simple reason that in such case there is no possibility for the accused during the first prosecution to be convicted for an offense that was then inexistent. Thus, where the accused was charged with physical injuries and after conviction the injured dies, the charge of homicide against the same accused does not put him twice in jeopardy. In the case of People versus Adil, expert evidence is not needed for anyone to understand that the scar of deformity that would be left by a wound on the face of a person cannot be predetermined. So now the expert evidence is not needed for anyone to understand that the scar or deformity that would be left by a wound on the face of a person cannot be predetermined. On the other hand, whether or not there is actually a deformity on the face of Vihar in relation to the case at bar, it is a question of fact that has to be determined by the trial court. And to relate this, on the case of People versus Adil, it's only the court who would be able to determine whether there was a scar or deformity on the face of Vihar. And that was the fact in question. To add, in the case of People versus Puling, it was explained on how a deformity may be considered as a supervening fact. It was quoted that no finding was made in the first examination that the injuries had caused deformity and the loss of the use of the right hand, as nothing was mentioned in the first medical certificate about the deformity and the loss of the use of the right hand. So, the court presumed that such fact was not apparent or could have been discernible at the time the first examination was made. Hence, the ruling in the case of People versus Adele. We are moving on to the last case of Group 9, and this is the case of People versus Relova. This was a petition for certiorari and mandamus regarding the decision of Honorable Benjamin Relova, the presiding judge of the Court of First Instance of Batangas, Second Branch, regarding the case filed against Manuel Opolencia. In this case, Batangas City Police, with the personnel of Batangas Electric Light System, through a search warrant, examined the premises of Opolencia Carpena Ice Plant and Cold Storage, and the police discovered that electric wiring, devices, contraptions were installed without the necessary authority from the city government, and they were architecturally concealed inside the walls of the buildings. Allegedly, Opolencia had it designed purposely to lower or decrease the readings of electric consumption, which he admitted. The complaint against him was filed for violating Ordinance Number 1, Series of 1974 of Batangas City by the Assistant City Fiscal in the City Court of Batangas. Opolencia pleaded not guilty and he filed a motion to dismiss, claiming the crime has already prescribed. When Opolencia claimed that the civil indemnity to be recovered was beyond the jurisdiction of the Batangas City Court, the claim was granted and it appeared that the offense was charged with light felony which prescribed 2 months from the discovery, but the fiscal filed the case 9 months later. In turn, a criminal case number 266 was filed again by the fiscal before the Court of First Instance of Batangas Branch 2 for theft of electric power in accordance to Article 308 of the Revised Penal Code. And Appalancia then filed a motion to quash, stating that he was already previously acquitted of the offense, and the respondent judge granted the accused's motion to quash and ordered the case to be dismissed. The issue in this case was whether or not the dismissal of the first case can be properly pleaded by the accused in the motion to quash. So let's go on to the ruling of this case. It was held that yes, Opalencia can invoke his right and properly pleaded motion to quash. And the case charges against him is covered by the second definition of double jeopardy since he was being punished of the same act. The Supreme Court stated that in the instant case, the relevant acts took place within the same time frame, from November 1974 to February 1975. During this period, the accused Manuel Opalencia installed or permitted the installation of electrical wiring and devices in his ice plant without obtaining the necessary permit or authorization from the municipal authorities. The accused conceded that he effected or permitted such unauthorized installation for the very purpose of reducing his electric power bill, and this corrupt intent was thus present from the very moment that such unauthorized installation began. The immediate physical effect of the unauthorized installation was the inward flow of electric current into Opalencia's ice plant without the corresponding recording thereof in his electric meter. So, in other words, the taking of electric current was integral with the unauthorized installation of electric wiring and devices. Taking a closer look on what the case is trying to teach us, the case mentioned Clause 20, Section 1 of the Bill of Rights, wherein it says that there are two kinds of double jeopardy. The first one is that no person shall be twice put in jeopardy of punishment for the same offense. And the second one is that if an act is punishable by a law or an ordinance, conviction or acquittal under either shall constitute a bar to another prosecution for the same act. This case also mentioned the comment of Associate Justice and later Chief Justice Roberto Concepcion explaining from the case of Yap versus Lutero that the first sentence prohibits double jeopardy of punishment for the same offense, whereas the second contemplates double jeopardy of punishment for the same act. And under the first sentence, one may be put twice in jeopardy of punishment of the same act, provided that he is charged with different offenses, or the offense charged in one case is not included in, or does not include, the crime charged in another case. The second sentence applies even if the offenses charged are not the same, owing it to the fact that one constitutes a violation of an ordinance and the other is a violation of a statute. So long as a jeopardy has attached under one of the information charging said offense, the defense may be availed in other case involving the same offense, even if there has been neither conviction nor acquittal of either case. And to sum it up, in the case of People versus Relova, it is very evident that the charges filed against Mr. Opalencia will fall on the second kind or definition of double jeopardy, wherein it contemplates double jeopardy of punishment for the same act. It further explains that even if the offenses charged are not the same, owing that the first charge constitutes a violation of an ordinance and the second charge was a violation against the revised penal code, the fact that the two charges sprung from one and the same act of conviction or acquittal under either the law or the ordinance, hence making it against the logic of double jeopardy. So the fact that Mr. Opulencio was acquitted on the first offense, it should bar the second complaint against him, which is coming from the same identity as the first offense that was charged against Opulencio. And that concludes the reporting of Group 9.